Good morning. I'd like to welcome you to our webinar today on the Enhanced Juvenile Justice Guidelines. My name is Jessica Pierce, and I will be your presenter and also host today. I'd like to thank you all for joining us to talk about this update to the seminal publication, the Juvenile Delinquency Guidelines. It's something that the NCJFCJ is very proud of, and we're excited that we get to do an update to it and reintroduce it to the juvenile justice community. I should mention that this project was funded by the State Justice Institute, and that all of the points of view expressed today are my own and my co-presenter, Dr. Melissa Sickmund, and they do not represent any official position either of SJI or the federal government. So I wanted to start out today by just talking a little bit about the National Council of Juvenile and Family Court Judges. I know that a lot of you are familiar with us, but if you're not, the National Council of Juvenile and Family Court Judges is a national nonprofit judicial membership organization, although we do have associate memberships as well for folks who aren't judges. Our mission is to provide all judges, courts, and related agencies involved with juveniles, families, and domestic violence cases with the knowledge and skills to improve the lives of families and children who seek justice. And really the way I tell folks to distill this is that our job is to make your jobs easier, right? You guys have a lot going on. You're working with kids and families every day, and that's hard work. And so really at the National Council, our job is to help you bridge that gap between practice and research. It's to help create tools that make what you do work better for you, and really hopefully help improve the outcomes in the lives of all of the staff that are working in the courts and the children and families in your community. As we're getting started today, I'd like to point out a couple of features in our Adobe Connect system. So we're using Adobe Connect today, and we have quite a few folks on the call today, which I really appreciate. I'm very excited to have such a big audience. But what that means is that all of your phones are muted if you're listening via phone, and of course if you're listening on your computer, your microphones have been muted. So all of our communication today is going to happen in the chat window. So if you would like to just take a minute and find the chat window, you don't have to type anything if you don't want to, but if you wanted to type in a hello, you're welcome to do so. And that is the best way to communicate with me and to get my attention to ask questions. And I'm going to ask you guys a lot of questions today because I think this should be pretty interactive. Juvenile justice and juvenile justice reform, I think, involves all of us, and so I'd like us to be working together on that. Great. It looks like lots of folks are finding the chat. Perfect. So as we're getting started today, there are a couple of folks that need to be thanked. And first of all, the State Justice Institute receives a big thank you from the National Council of Juvenile and Family Court Judges for supporting this update to the Juvenile Delinquency Guidelines. The Juvenile Delinquency Guidelines, was published originally just about 15 years ago, and since then things have changed, and we have been looking for someone to partner with to make changes and updates to the document for a couple of years. And so the fact that the State Justice Institute was available and stepped up and wanted to help create this update is enormously helpful to us, and we are very, very grateful that they were able to do that. And then the other folks I really want to thank are the Update Committee. So the Update Committee is made up of folks who participated at the first time we created the Juvenile Delinquency Guidelines. They're made up of folks representing national organizations, the National Juvenile Defender Center, the Coalition for Juvenile Justice. We have representatives from the prosecutors. We have probation folks. It was this committee who really came together, a lot of our member judges, and they were all very, very willing to do some hard work for me. And so I would be remiss if I did not say thank you to all of them. And there's actually one person who I left off my list here, which is Andrew Wachter, who works at our National Center for Juvenile Justice. He did all of the reference updates. If you're familiar with the original Juvenile Delinquency Guidelines, you'll know that there are about 700 references in the document. And he went through those with a fine-tooth comb and updated all of the things that could be updated. And so, again, we're really excited that we were able to undertake this journey to create a new version of this publication that's been so important to us at the National Council and hopefully to all of you who are working in juvenile justice. So I want to know how much you know about the original Juvenile Delinquency Guidelines. So I'm pulling up a poll now, and if you could just let me know. And this is the original, the publication that came out in the early 2000s. And I'm going to let you all see the answers too. So you can see we have folks that that ranged from people who helped create them, but a lot of people who've heard of them but maybe haven't used them regularly. And we're hoping to change that. So for those of you that have answered, I've heard of them, but maybe aren't using them in your day-to-day lives, we're hoping that we can give you this tool, this resource to help you as you're working with kids. Thank you all for answering my poll. All right, so I'd like to introduce you then to the Enhanced Juvenile Justice Guidelines. So you can see there was our old publication, the old Juvenile Delinquency Guidelines, and then as if by magic, it becomes this. So one of our very happiest moments that we had when we were doing the update is that we realized we would get to change the cover. So back in the early 2000s, that old Marvel cover looked pretty sharp. We thought, you know, that's an official-looking publication. But things have moved on as far as design goes, and we are very excited to move to something that looks a little more modern. So we like this very much with the young people. We're very pleased. All right, so I'm very excited to introduce then the Enhanced Juvenile Justice Guidelines. And as we're getting started talking about this, I want to know from all of you what you think the most important thing, is in juvenile court case processing. What's the most important aspect of juvenile justice court case processing? And I've left this question deliberately open and pretty broad, so please type in chat what you think is most important when we're having young people who come to court. And Melissa Sickman, my co-presenter, she's saying intake. So whenever we get them there right at that very first moment, we're giving them the very best that we can give them. And we're finding out kind of where they need to go. All right, we've got risk and need assessment. Yeah, so really the best thing that's happened, I think, if we think about what's changed over the last 15 years, is that we're a little bit better able to match kids to services based on risk and need. Access to justice, dealing with the family. Yeah, absolutely. Being aware of and responding to racial biases, having good representation, that we have actually good outcomes for the kids, right? We're not just doing this so that we can say that we did it. We want something to change in the lives of those kids and families. And we know that they're scared and that we want to help them through the process. And Judge Romero, you're adding in that we want to make sure that we're engaging with tribal entities as well. If we have kids that come from a tribe, that we make sure that we're giving them back to their tribes, that they get to have a say in what's going to happen to their youth. Timeliness. Yes, absolutely, Hunter. We want to make sure that kids aren't just languishing in our system, that the child and family understands the process. This can be a really intimidating situation for kids and families, and if we don't do something to help them understand the process, then they're not going to feel like the outcomes worked for them, right? Having a voice. Yes. And we have respect, with a little shout out to Aretha Franklin. Yes, absolutely. Respecting the kids and families that come to our courts, that they're better off coming out than they were coming in. Yeah, recognizing trauma, and not just trauma that kids come in with, but the fact that this is traumatic for them, right? That this is not something that they're comfortable with. This can be scary. Oh, these are all great. Keeping it personalized, individualized responses. Yes, Gary, I absolutely agree. That's something that it's hard to do, right? Because in the system, it gets easy to kind of do things that are easy for us. But what we want is we want to keep the kids and the families at the forefront, and we want to do things that are going to help them. So these were all of the things that we were thinking about when we first wrote the Juvenile Delinquency Guidelines, and then as we were doing the updates. You guys are exactly where we were when we wanted to talk about these things. We wanted all of these aspects that you've all shared to be at the forefront of this document, and at the forefront, really, of our juvenile justice system. So I just want to take 1 minute to talk a little bit about the history of the Enhanced Juvenile Justice Guidelines, and really where we started, which was with the Juvenile Delinquency Guidelines. So the Juvenile Delinquency Guidelines really started from our resource guidelines, which we developed for dependency court. And of course, with dependency court, providing courts with some really specific guidelines and timelines and direction was very, very important because of the Adoptions and Safe Families Act. The Adoptions and Safe Families Act really put the dependency courts in a position where they had some very specific rules that they needed to follow, right, and some really specific timelines. And so it behooved us at the National Council to provide them with support and information that they could use to really meet those guidelines. And so after we had completed those, it really occurred to our judge members and all of the staff that even though the Adoptions and Safe Families Act was driving the development of that, that the whole idea of guidelines and helping courts with case processing and figuring out how to move youth through the process as efficiently as possible while making sure that they had access to counsel, that we were being cognizant of racial and ethnic disparities, and making sure that for those kids that come from tribes, we're reconnecting them to their tribes. For all of those different reasons, we would want to make sure that we had guidelines and direction for courts that were dealing with delinquency cases as well. And so that really is where our juvenile delinquency guidelines came from. And then you've heard me mention that things changed, right? So things are not the same now as they were 15 years ago. And as things started to change, it became apparent that we were going to need to do an update to this document. And so we looked around for some funding, but it really was important to us to make sure that we were reflecting the most accurate and up-to-date information possible. And so now I want to ask all of you, I know a lot of you have worked in juvenile justice for a while, and so what do you think has changed the most in juvenile justice over the last 15 years or so? You can go ahead and type your answers in chat again. Oh, an understanding of trauma and a focus on adolescent development. Yeah. Moving away from a law enforcement model. And, you know, we talk about a pendulum swinging in juvenile justice all the time. And especially back in the early 2000s, we were very much focused on compliance. And we wanted to move away from that into something that's more about competency development and understanding the development of adolescents. Judge Edwards, recognizing that the child's brains aren't fully developed until they're 26. Yeah, I mean, doesn't that change your whole perspective when you're dealing with teens to realize that there's stuff happening in their brains all the way till their mid-20s? I think Spokane County, you're mentioning risk assessments. I think risk assessments have been around, but they've gotten so much better and more sophisticated. Examining data. Yeah, we really have been putting a much stronger emphasis on data and how courts can use data to think about their own practice. That we're kind of always reforming and trying to strive to be better. Diversion options. Yeah, I think courts really have focused a lot of their energy over the last decade or so on creating better diversion options and really more specific programs, right? That kids aren't just everybody, it's not a one-size-fits-all anymore. Everybody's going to something that really matches them, so that we get to where Melissa Sickman is saying less is more. We know that kids don't have to be in the system, and the research really indicates that, right? That for the most part, crime really desists over time because people grow out of it a little bit, right? Those delinquent behaviors do not continue into our late 20s and 30s. And of course, Hunter, the juvenile arrest rate has plummeted nationally. And so there are fewer kids now to come into the system. And so I think that probably gives us a little bit of a luxury to help figure out which kids need low-risk interventions and which kids need maybe a little bit more of an intervention. Jennifer, you're saying community-focused? Yeah, we want to keep our kids in their communities whenever possible. We want to keep the community safe, right? We don't want them to feel like we're putting the community in danger, but whenever we can, we know that those links to the community, that having kids in their own neighborhoods, dealing with those caring adults in those neighborhoods, those are going to be the best links that we can help them form to go on to be successful. Developing and implementing alternatives to secure detention. Yeah, the Juvenile Detention Alternatives Initiative from the Annie E. Casey Foundation has really changed a lot about how we think about our kids and what we can do. The technology got better too, right? Like, so electronic monitoring and house arrest and those things that keep kids in their communities while still keeping them in a kind of a secure environment have made things easier for us. Now, I'm not necessarily advocating for putting everyone on electronic monitoring, but it certainly has changed over the last 10 years to make things a little bit easier. We have a commitment to alternatives to detention. Courts are really focused on that, and it's always fun when we go out and we talk to courts. One of the first things they always want to tell us is their detention bed census. Like, oh, we have 40 beds, but only 3 of them are occupied this week. And so you guys are all really proud and excited about the changes that you're making around that. And we have Shavante saying, recognizing that arrest and detention can cause more harm. And that's exactly right. We know these things. We have this research, and we're really starting to understand how we can do that. We have a better understanding of the families and how we really need to work with the families, and maybe having parents who are being thrown in jail because their kid is truant isn't necessarily the best way for us to make that connection with that family, right? So we really have changed a little bit about how we want to perceive kids, how we want to perceive parents, and the role that we think that the court plays in a community rather than being kind of separate from the community. A lot of your courts are starting to feel like they're part of the community in that way. Wow, so many great answers. So again, when we were approaching this to talk about changes that needed to be made to the Juvenile Delinquency Guidelines, these were exactly the things that we wanted to talk about. And I know we have some committee members on the call, and I appreciate all of you guys being here. This was a big part of our conversation, was what has changed and what do we really want to make sure that we update in this document. And so it's all of this. Focusing on detention, reform, thinking about adolescent development. Oh, I see, Dana, you're talking about the ACEs. Yeah, ACEs and trauma, even though we know that those aren't necessarily big factors for driving delinquent behavior, we also know that we have kind of a responsibility to the kids and families that come to us, that we recognize that these things are happening in their lives and that we are compassionate, that we're respectful, and that we are helping them get to the services that they need. I always say we want kids to become the adults we want them to be. So what's our role as court members in doing that, right? All right. I'm so excited. You guys are reform-minded. I appreciate that. So I want to tell you a little bit about the update process. We started out, as I said, with this idea that we're going to talk about all of the different things that have changed and what really needs to be updated. And so I had that committee. We had an in-person meeting with 10 of that committee, but the entire committee is about 30 folks. And like Judge Len Edwards, he's always willing to send it out to other judges he knows. And so I think over the course of the review and everything, I've had about 50 or so people who've reviewed and commented on the changes that needed to be made to the document. And so that's amazing, that's wonderful, and it was a lot. We needed to change language. So you'll notice that the previous title of the document was the Juvenile Delinquency Guidelines. But we wanted to, and I think that the focus on language and reform within the juvenile justice system is important. We wanted to take the emphasis off of the word delinquent and off of the idea of delinquency and kids being delinquents, right? We wanted to talk about kids as youth, as assets to themselves and their communities. And so we really did want to change the focus of the language. And so that's why we're talking about the Juvenile Justice Guidelines, not delinquency guidelines anymore. Because, again, thinking about all of the changes that have happened, and even changes that were happening at the time, we recognize that kids are more than whatever delinquent act they have committed when they come to court. And so what can we do to reframe our focus? And so we changed the language. There are new practices that are happening in court, right? There are new things that happen in practice, and you guys have listed a lot of those. And there are new recommended practices. We have new recommended practices coming out a lot, right? Especially right now, we have things we're talking about not shackling kids. We're talking about fines and fees reform, where we're not necessarily charging kids and their families in the same way. And again, we have to be thoughtful about victims and restitution always. But we're thinking about those things in a new way. We have more and better research about youth and crime. There's some nice longevity studies now about youth and crime, and we can make some good predictions about which kids are likely to continue being involved in the criminal justice system and which kids aren't. And then we had, of course, and this was the big reason we needed to change things, we had some really monumental Supreme Court rulings that needed to be highlighted. And so the update really had a lot of things that we wanted to focus on. And again, the process was a lot. I asked a lot of the committee, and again, I'm very, very grateful to them because they all did this without getting paid. They all did this because they believe in juvenile justice reform, that they believe in the voice of the judge as the leader and convener. They believe in the role of prosecutors, defense attorneys, probation officers, judges coming together to provide the field with this information. And so it was a big lift, and we've been working on this for just a little bit more than a year. And so I really just wanted to talk about the process a little bit. And now I've broken all of the rules of a good PowerPoint on this slide because I really wanted to show you all of the things that happened. So the update committee, those 10 or so folks that were able to meet in person, met in December 2017, so exactly a year ago. Before the meeting, I asked each member of that committee to read a chapter and identified these big picture changes that were going to need to be made. At that meeting, we discussed each chapter and all of those proposed changes. Then I took all of that and I went home and I made a first round of edits. And like the first thing I did is I did a search and replace, right? I took out the word delinquency everywhere that it was occurring and I put in the word justice. That was a pretty easy one. But there were a lot that were less easy. And so once I would update a chapter, I'd have the whole committee get back online, just like we're doing now, and go through the chapter with me again and talk about any areas that got flagged, either by me or by one of them as reviewers. So every month we're looking at in-depth each chapter to talk about things. And there were some parts that that I don't think I anticipated having a big conversation about. There was a big section on plea agreements where we spent probably 45 minutes talking about plea agreements and what really made sense for recommendations. And so there was, I think, a lot of work on the part of the committee. Every month they would review the chapter, then they'd get on the call with me, give me feedback, and then I made all of those changes and I made them read it again. So now there's several folks who have read some of these chapters 2 or 3 times. And so that's where we're at now. The final round of reviews are happening now from the committee. They're looking at them, and we're going to publish. So you'll notice I'm not taking you out to show you the website yet where this new document's going to live, and that's because we're not actually going live until December 31st. But because you've all signed up for the webinar, we will send you a notice when the website goes live, and of course there'll be some press releases and that kind of fun stuff too. But we are still working on the editing process, and the committee was so great to hang in there with me, always looking at these things, having really great, thoughtful conversations. So I wanted to talk a little bit now about our key principles. The key principles are really important to NCJFCJ projects. This is where we really distill these ideas down into principles. What do we believe in? So for the Juvenile Delinquency Guidelines to become the Enhanced Juvenile Justice Guidelines, we wanted to change our key principles a little bit. And one of the things that we did is we grouped them, because we had kind of two focuses. And the document itself, as you're reading it, you'll see it has two focuses, which is on youth and family-facing procedures and beliefs, and then on just kind of general court procedures and beliefs, right? So we have the key principles now grouped as fairness, equity, and procedural justice. Those are for the key principles that are about kids and families. And then we have the pursuit of excellence, and that's about improving court systems and practices. That's where all of that good stuff about like data, collecting it, reviewing it, doing something about it, that's where that all comes in. And we added two key principles. Equity of access, so really talking about racial and ethnic disparities and making sure we have equity of access, and adolescent development. And so when you're looking at the key principles, again, these are really just what we think all of the Enhanced Juvenile Justice Guidelines, what they all boil down to. So we want to make sure that that we're working to promote equity and impartiality within the entire court system, that kids and families are treated with respect, that kids who don't need to come into the system don't come into the system, that kids have representation, that they have an attorney at every stage of the process, and that it's the same attorney as often as is possible, that crime victims have access to all phases of the process, and that we're making sure that they're getting what they need, and that we're making sure our courts are friendly to victims, which means that when a victim comes to court, they get to have a separate waiting area, that they're getting all of the appropriate notifications, right? Those are all those things that we really believe lead to fairness, equity, and procedural justice. We also really want things to be timely, right? When we talk about adolescent development, that kids and their brains, that operates differently. They're very concrete thinkers, and if we're going to have a consequence for a behavior, it's best if that consequence happens as close to that behavior as it can, right? That's how you connect things. That's how you make those changes in the brain. We want court staff to engage with parents and think about parents as a potential resource. And that's a heavy lift, right? Because families and parents can sometimes seem like they're a big part of the problem. And so it really does take, I think, conscious effort every day on the part of all of you who work with kids and families to make that effort to say, I'm going to find something to work with these parents and these extended family members. I'm going to make an effort here to work and engage with them, right? That we're engaging with schools. We know educational outcomes are so important to our kids being successful. That we're going to ensure that these dispositions are individualized. So thinking about schools, you have kids that come into court, right, that are perfectly good students. And so what's our job to help them reach their next level? What's their potential? How can we tap into their strengths that they bring to the court and help them become those adults that we know they can be? We want courts to understand adolescent development and, of course, use graduated responses. So now when we think about pursuit of excellence, these are things where we're talking about how we want our judges to be leaders within their systems and within their communities as much as they're allowed to be. We all know that sometimes juvenile courts are the least funded, least important as far as some folks think of the court system. So we want to make sure that we're always advocating that juvenile courts are adequately staffed and funded. Whenever possible, we encourage the implementation of a one-judge, one-family model. We want our judges to have the same status as any other judge, and we'd like them to stay at their assignments, right? Rotation of judges sometimes can really cause challenges, especially in juvenile court. We want judges to have the ability to hold system members accountable, We want to make sure that you have access to good MIS systems and that the MIS system actually works for you. It's not just a dust catcher and collector of data that goes off to the state that you never hear again, that it's actually useful to your own court. We want to make sure that post-dispositional review is happening, that kids that are coming through the system get post-dispositional review, that we're checking and making sure that what we thought was going to happen happened and that it was helpful, right? We want to make sure that everybody has adequate training, and training is hard sometimes, right? Training, finding the hours, finding the time, and getting everybody trained is tricky, but it's really important. It means that we have staff that are competent, that we know that they can perform their jobs to the very best of their abilities. All right, so let's talk about changes to the guidelines themselves. So let's go back and go through that list again. So we updated the language. The title changed. We really want to focus more on the idea of justice for kids, and that we're not focusing on offenses and thinking about them as offenders. We remove terms that are no longer used. So as our language changes and gets updated, there are some terms that kind of fall out of favor. The term mental retardation was still included in the original version of the delinquency guidelines. We changed that. We added new language. So we know that we have kids who are coming into the system that are of a variety of sexual orientations, that have gender identity differences in how they present maybe within court, and so we really wanted to make sure that we were reflecting that in our language as well. So we included all of those kinds of language updates. We know that there's changes in practice, and so we want this to be both reflective of what's currently occurring in court and recommending kind of what we think of as recommended practice. So we wanted to reflect those changes that are actually happening, things that we know courts are doing, like an increased use of the risk, need, and responsivity tools, the increased use of diversion, and you can see it's all what you guys have in your list, the reduction in the use of detention, changes in ways in which cases are dismissed and processed. This has become, I think, one of the most interesting things is that cases don't always have to come back to the judge, right? A lot of times they get dismissed a little more informally, so we're seeing a lot of that. One of the most interesting parts of our updates actually are changes in practice around privacy. At the time in 2003 when we were kind of starting the process to update or to create the delinquency guidelines, there was a big move toward open juvenile courts. And because when juvenile courts were happening behind closed doors, there was kind of a feeling that maybe the public didn't really know and couldn't trust the court. So we were really moving toward open court. And we were also moving toward fingerprinting and photographing the kids, doing all of those kinds of things. And now, over the time that has come, the intervening time, there's a move to move back toward a little more privacy, with states who are now automatically expunging records, with the internet and how juvenile arrests and juvenile case processing doesn't just go away because you can find almost anything you'd like to know on the internet. We've been rethinking privacy, and so that's one of those things that's changed that I'm not sure that we necessarily expected when we were writing the original document. And now we're going to talk a little bit about changes in recommended practice, and I've actually asked Dr. Melissa Sickman from the National Center for Juvenile Justice to talk about these things because she's kind of an authority on both the changes in practice and then also the changes at the Supreme Court. So, Melissa, are you there?
Thank you, Jessica.
You're welcome.
And hello, everyone. Yeah, I mean, Jessica asked me to talk a little bit about, changes to things like the risk, needs, responsivity tools, and just, I think, applying those principles. Again, based on research, having risk needs assessment is sort of the foundation of evidence-based practices. Enhancing efforts to treat youth who have violated the law, to reduce recidivism, and to ultimately to increase public safety. So in most states, we find that there is a uniform risk assessment or risk needs assessment instrument that's being used statewide to gauge the likelihood that a youth will reoffend, and then to help guide case planning by identifying and prioritizing the criminogenic needs and understanding what are the best approaches to meet that child where they are so that they will be responsive to the treatment or whatever is being provided to them. Issues around adolescent development and brain science are things that, I don't know, just a lot of information was piling up. In 2013, the National Academies published Reforming Juvenile Justice, a Developmental Approach. And before that, there was real concern that the juvenile justice system was not really respecting human development, although, 100 years plus ago, the system was founded on the notion that kids were different from adults and needed their own system. The due process and harsher punishment phases that had come in the intervening years had kind of changed that. And so there was a real focus, except now there was, brain science, scans of kids' brains at different stages of development that showed us that the frontal lobe is not fully developed and typically doesn't fully develop till a person is about the age of 24 or 25. So that area of the brain that controls judgment and impulse control and emotion and reasoning and problem solving, that's the last to mature. So maybe we need to rethink how we're holding kids responsible, and maybe we need to do things differently to be more effective in reducing their subsequent offending. So a lot of states were maybe already paying attention to those things. When that publication came out, I think there was a lot of additional attention given, but that also affects the things that are sort of on this slide, the shackling of youth that causes trauma, that has a negative impact on that brain development. Changes in thinking about privacy can certainly be, connected back to if you're, I think, Jessica, you said it before about, we're not going to label this kid whatever their worst bad behavior was. We don't want that to kind of haunt them the rest of their lives. You heard people talking about collateral consequences of involvement in the system. So if being in the system prevents you from going back to high school or going into college, that harms things, and we don't want it. Obviously, even before the original publication, there was a focus on disproportionate minority involvement in the system. That certainly continues, and I think now we are considering fairness. It's not just racial and ethnic disparities. It's disparities against lots of other different types of groups of kids. The issue, I think maybe is on your next slide, Jess, too, about adolescent recidivism, and I would sort of add just sort of the notion of evidence-based practices and programs. There is an increased expectation, I think, that the system, different components to it, and I would argue probably should be the court's responsibility to understand reoffending of the kids that come through the system. That's juvenile justice services are increasingly required to implement practices and program interventions that are supported by research and evaluation that can demonstrate that they are reducing the likelihood of subsequent offending. They can't do that without understanding without having the data to show that. Not every program can evaluate itself. That often is very costly. But I think courts have a responsibility to look at their data because they are sort of the hub of the system to be able to measure reoffending so that we can understand. I mean, it is kind of crazy to measure the system's success by measuring its failure. So we also want to think of adding other measures of positive youth development. But the notion of the system also being accountable to do a good job is something that I think maybe was I don't know, first sort of really came into my awareness when back in the late 80s, early 90s, we were talking about balanced and restorative justice. And those principles of balanced and restorative justice, of community protection, competency development, and accountability to victims and the community for the harm that's been caused in balance, together with the system being accountable to do all those things well, that's in the purpose clauses of 34 states. So that's the most common purpose that states put forth of what their juvenile justice system is about. 5 of those states also mention the use or mention adolescent development or reliance on research and data to assist the system or require the use of evidence-based practices. So it's sort of new and refreshing for the system to say, hey, we need to make sure we are doing a good job. If the system fails, let's not blame that on the kids. And then the next slide you had, Jess, was the Supreme Court decisions. I think the ones that have drawn the most attention are the series of decisions that related to the death penalty and life without parole. So Roper in 2005 was dealing with the imposition of the death penalty and basically set the age limit at 18, that below that it was cruel and unusual punishment. And the court cited lack of maturity, an underdeveloped sense of responsibility, and juveniles being susceptible to peer pressure, and that the personality traits of juveniles are not as fixed as adults. They were citing and referencing some of the research on adolescent development and some of the brain science stuff that had come out prior to that. Graham was dealing with life without parole for non-homicide cases, again saying juvenile offenders have limited culpability and that life sentences were extremely punitive for non-homicide offenders, again citing the adolescent development and brain research that had been done. And Miller, again, forbidding mandatory life without parole for the juvenile homicide offenders, combining the reasoning from the prior 2 cases. So in each of these cases, the court relied upon scientific research to conclude that even the youth who were doing really serious things still have the capacity to change. That's kind of the foundation of juvenile justice in this country. Because of their developmental immaturity, their susceptibility to negative peer influences, their imperfect decision-making, that they are less blameworthy for the things that they do than are adults. So those things, the use of and citation of the adolescent development research was sort of a big deal and anchored those things. So that when the national academies came out with Reforming Juvenile Justice, a Developmental Approach, it was sort of like this is real. Now, that's not to say that the accountability that kids that have been found to violate the law sort of have that accountability to victims and the community. I don't think we should forget those things. I mean, we still have to keep those community protection, competency development, and accountability in balance. But it's such a different environment now for talking about how to make the system work better than it was back in the mid-90s. That was sort of everybody was afraid. The violence rates had gone up so high. Now everything is different with the rate of arrest, the caseloads are smaller, fewer kids in detention, fewer kids placed out of home. As you mentioned, Jessica, we sort of have the luxury now to really look reflective, to look at the system and say, what do we need to change to do a better job? And so these enhanced guidelines provide a lot of practical advice on what to do differently.
Thank Thank you, Melissa. I think, it's always fascinating to think about the reduction in juvenile crime and crime across the board. That would be a fun webinar to do maybe sometime in the future.
Yeah, what would have changed or changed differently if those things hadn't happened?
Yeah, I mean, you can imagine we would be this would be a very different conversation.
Mm-hmm.
So, yeah. I do want to talk about the change in the format to the document too, because I think that one of the other things that's changed, which may be affecting juvenile crime, is everyone's access to technology. So I remember when we published the original Juvenile Delinquency Guidelines, we had it available in two formats. You could get the big spiral-bound book, which many of you probably can glance over and see on your bookshelf right now, or we also were giving it away as a CD. So you could also get this electronically on a CD, which it was actually someone's job to copy here at the office to send off to people. And so those were our two options technologically. But and then, we put it on the website, but the website wasn't really the way websites are now. So one of the things we're very excited about is that we're really publishing this electronically. It's a handy publication when you have it as the big book, but honestly, you think about how folks are going to use it. I think about how all of you on this webinar are going to use it. And it's likely that you're not going to want to sit down and kind of look through the index and thumb around the tabs to find what you're looking for. You're going to want to kind of search for a term like fines and fees or fingerprinting and sort of see what we have that's available to you for those topics. And so with the publication being electronic, I think it's going to make it a little bit more user-friendly for folks. I think it'll feel a little bit more like a web-based resource. It won't just be, here's the document, download it if you want to. It'll be something you can look at. We're going to have lots of links. So when I was thinking about the risk, need, and responsivity section of this document, which got a huge overhaul, I also was thinking about how there's a lot of stuff that other people have already written about those topics. And the committee kept saying, oh, have you looked at this? Here's this resource. Maybe we should include this. And I thought, well, this is starting to feel a little bit overwhelming. And so what it makes the most sense, I think, is for us to provide sort of what the guidance is for courts on like a policy level and a procedure level. And then here's a link to all of the research. Here's a link to practical tools that you can go and check out. And so that's what you'll see when we have the document published. You'll be able to go out to links. There'll be supporting documents. We have these great bench cards that we've been developing over the last few years. So we have a bench card on sexual orientation and gender identity. So if you want to kind of delve a little more deeply into how to work with those youth in your court, we have a bench card on fines and fees. So if you're not quite sure what the National Council is recommending on fines and fees, we have both a resolution and also that bench card, which really goes through those things. So I think you'll be able to find not only our recommendations, but then all of the supporting documentation, and then again, links to practical tools that other folks have developed. All right, so for our last few minutes, I want to ask you guys two questions, because I imagine that we're going to do this process again. And I'd like to be ahead of the editing process for the future. The other good thing about this document living online is that it's going to be much easier for us to update. So I'd like you to imagine we're 10 years from now. So 10 years into the future, what things will we be talking about that have changed between now and 10 years from now? So what sorts of things do we see on the horizon for changes in juvenile justice? I know some folks are like, there will be no juvenile justice system left. We will have abolished it. Using technology for treatment. Yeah, like telemedicine and telecounseling is all really interesting, and like text message reminders for kids who are, in drug courts. Those are all very interesting. Oh, racial and ethnic disparities when Hispanics are majority in many places. So that will kind of turn things on their head. Focus on dependency cases and best practices. We'll have more and better ways to keep law-breaking youth in the communities, more wraparound approaches that are going to involve the families. We'll start to encompass the emerging adults. Yeah, I see that really as a big focus for our judges, that when we're talking about raise the age, it's no longer just to raise the age to 18, but a lot of them are talking about what can we be doing for those kids all the way up to 25. Fewer detention centers. Yeah, we're seeing tons of detention centers already that are closing or becoming something different, and so I think that will be really different. We're going to have better cohesion as far as our stakeholders being on the same page with working with families to get best outcomes. Youth and peer recovery implementation more widespread. Yeah, I've seen some really great stuff around peer support networks for kids. And when you talk to young people, it's very clear that they want to be involved, not only in decisions for themselves, but for their whole cohort of young people, right? So you have youth who want to support their peers as they go through this. So like peer courts, raising the floor so that very young children aren't prosecuted in juvenile court. That has been changing slowly, and we're seeing some of that, but it would be really wonderful if we see more and more of that. We're going to have more youth and family voice in our systems. I think that would be good. And yet, so I like this, the taxpayers will accept that other alternatives are more cost-effective. Yeah, sometimes taxpayers like I think the false sense of comfort that comes from when somebody gets locked up, because then we don't have to think about them. And even some families like that, right? Like, if they're in detention, I know I don't have to worry. But that's not always going to help us get the best outcomes. And it costs us the most money. Oh, the use of AI and predictive analytics. There's a lot of folks that are thinking about this right now, and it is so interesting to imagine the fights that we're going to have in the future between protecting individual rights and defense, and also being able to really kind of know, right? Just like how Facebook knows if I've visited a web page and they want to try to sell me an air fryer when I go on to check my updates. More focus on prevention and integration of health and wellness. I like that very much. Pre-court diversion and more accessibility to those kinds of things. A better focus on restorative justice. I think you'll notice like a couple of times I had that kind of caveat of, don't worry, we're going to think about the victims. And I know when we think about juvenile justice reform that sometimes folks feel like we leave the victims out. And so when we're thinking about restorative justice and bringing victim voice into the process, I think it's really important that we think about that thoughtfully and what role victims can play in that restorative justice process. More money for programs. And again, when we think about our key principles, we really want better funding for our juvenile courts so we can have things like functional family therapy, multidimensional therapy, because we know those actually change outcomes for folks. And it's hard sometimes to sell the community on it, or to sell administrations on it, sell the legislatures on it, but it actually is the most cost-effective way to do things, right? If we can help heal what's happening for those kids and their communities and their families, then they're less likely to come into the system. It saves us money in the long run. More incentives to keep juvenile court judges in juvenile court. Yes. At the National Council, of course, we have tons of judges who have made this their life's work. This is their passion. But I think there are other judges out there that would be willing to do this too if there were the right incentives in place. And I think that that's really important, again, to raising the profile of juvenile court and making juvenile court a really important and central part of a community. Increased funding to extend evidence-based services to status offenders. Yeah, we don't want status offenders to come to court, but we don't want them to be left out of receiving services altogether. You shouldn't have to commit a crime to get the help you need. So how do we make that balance? We want to have our communities have greater involvement and ownership. Yeah, we do. We want the community to feel like these kids are their kids. Even if they've made a mistake, even if they've done something serious, they still belong to the community. And we don't want the community to feel like they have to push those kids out. So how can we help that happen? Oh, these are good answers. All right, so in our last few minutes, I want to tell you about our next steps. We don't have funding yet for our next steps. So these are our aspirational next steps. I'm confident we're going to find some funding to do this. So we want to add demonstration sites. When we want to think about this, we want courts, again, to practice with these guidelines. We want to come out to your courts, and we want you to tell us what's working and what doesn't work, and how can we improve the guidelines as we go along, right? We want to create support tools. So what kinds of tools do you need besides the guidelines themselves to help implement these things? Is it bench cards? Is it questionnaires and forms to fill out? Is it just more training and guidance? We're going to present more at national conferences and state conferences, and we're going to really just get the word out. And then we're going to have more webinars on specific topics from the Enhanced Juvenile Justice Guidelines. Again, these are our aspirations. We're looking for funding to get this next step off the ground, but hopefully you'll be hearing from us in the spring or summer about kind of where we're going with that. And so my final question for you is, what tools and resources would you like to see us create? So again, thinking about the fact that we're going to definitely have a phase 2 somehow. What additional resources would you want us to create to help you do your jobs in the very best way that you can? Gender-specific assessments and evaluations. Yeah, I think not just gender, but race and ethnicities too. We have tools that are normed, but not necessarily normed across a broad population. I know for like Native American kids, there's really a paucity of availability in those tools. A listserv to communicate with each other. Oh, that'd be fun. Kind of a big juvenile justice listserv where you can ask questions and make suggestions. I like that. More training on graduated sections. I like that. This is a great idea. Prepare a PowerPoint to make available to judges and probation officers so that like when you guys are talking with your peers about this stuff, you kind of have some talking points and some resources that you yourselves can use. And Hazel, you say, can I help obtain education or link you to experts that are willing to be part of a webinar? Yes, Hazel, we can do that even without our next steps for the Enhanced Juvenile Justice Guidelines. If you want to send me an email, I'm happy to help you with that. More training for mental health cases. I think really getting those foundational topics when we do this next step, that would be very helpful. Tools to increase school and justice partnerships. And Candy, we actually have some of those on our website already, and we're hoping to create more, so I would definitely recommend checking those out, and then we'll keep that in mind. Oh, professional or national standards for certifying juvenile court staff. That is very aspirational, Spokane. I appreciate that. We'll see what we can do. All right, focus on stress and how it affects health and wellness. Yeah, stress not just among our kids, but basically anybody, right? All of you too. Okay, well, this has been really fun. I appreciate you all spending the last hour learning about the Enhanced Juvenile Justice Guidelines. As I say, you'll all get an email when we take this live. We're very excited to have this new and improved resource out there for you. And we'll keep you updated about next steps as well. Hopefully maybe a couple of you would be willing to be demonstration sites for us. So I appreciate your time and attention today, and I'd like to thank Melissa Sickman for jumping in and kind of being the official resource for us. And have a great rest of your day and a lovely rest of your year. Thanks, everybody.